Welcome to the deep dive. Today we're cutting through the legal drywall, so to speak. We're looking at a really common problem. When does that hard sell language for a house cross the line from just, advertising puffery into actual actionable fraud? We're diving into a specific case here, Jacobson v. Hofgard from the DC District Court. Think about this scenario. A couple buys this expensive townhouse, like $640,000, advertised as a stunningly renovated home, but behind that fresh paint, they find major problems. Structural issues, bad plumbing, unlicensed contractors did the work, and maybe worst of all, a basement kitchen that turns out to be totally illegal because of zoning rules. So naturally, they felt swindled. But the legal puzzle for you, the learner, is figuring out which of the seller's statements could actually form the basis of a lawsuit and which are just, well, sales talk.
Exactly. That's our mission today. We need to isolate the six essential elements you absolutely must prove for a fraudulent misrepresentation claim under DC law. And crucially, we're going to spend real time on how the court distinguished between that legal sales talk hyperbole and this really critical concept called the half-truth rule. We'll use the FIRAC method facts, issue, rule, analysis, conclusion to break down the court's thinking step by step, see why some claims worked and others just didn't.
Okay, let's unpack this then. So if buyers like the ones in Jacobson believe they were tricked, essentially, into buying a house with all these hidden defects, unlicensed work, no permits, hidden flaws, what are the basic things they have to prove? The building blocks for that fraud claim.
Right. Under DC law, and this is pretty standard, you've got to prove six things. All six, miss one, and the whole claim falls apart. Okay, number one. A false representation. Now, this could be an outright lie, or, and this is key for Jacobson, it could be failing to disclose something important when you actually had a duty to speak up. Two, it has to be about a material fact, meaning it has to be important enough to actually influence a reasonable person deciding whether to buy the place. Three, it must be made with knowledge of its falsity. The lawyers call this scienter. They knew it was false. Four, there must be an intent to deceive the buyer. Five, the buyer took action in reliance on that false statement. They bought the house because of it. And finally, number six, that reliance led directly to provable damages. They lost money or value because of the lie.
I want to pause on number three, scienter, knowledge. It seems really hard to prove a seller knew the kitchen was illegal, for instance. How does that actually work in practice?
Oh, it's definitely the toughest hurdle, usually. Scienter isn't just forgetting. It means they knew. They knew the zoning was wrong, or they knew the contractor wasn't licensed and might cause problems, and they deliberately hid that fact when advertising. Often, proving it requires finding evidence like warning letters, city notices, or maybe emails showing they discussed using unlicensed guys specifically to, avoid permits and inspections. A paper trail helps.
And what about the buyer's side of things, especially in a big deal like buying a house? Don't buyers have a responsibility to check things out themselves? Do their own inspection?
Absolutely. That's a critical piece, especially for commercial contracts, like a house sale, negotiated at arm's length. We have to add that the buyer's reliance on the seller's statement must be reasonable. And that reasonableness element, that's precisely where the court drew the line in Jacobson between the two main advertising phrases. Stunning renovation versus newly renovated. One was deemed puffery you couldn't reasonably rely on, the other wasn't.
Okay, let's test that first element then, the false representation, using Jacobson. The sellers advertised the house in two key ways regarding the work done. They called it a stunning renovation and also said it was newly renovated. Why did the court treat those two phrases so differently from a legal standpoint?
Right, this is where we hit that concept of puffery head on. The court found a really clear distinction. Let's break down the stunning part first, using that FIRAC structure. Hashtag A structure dialogue on puffery, the stunning renovation claim.
Okay, let's analyze Jacobson v. Hofgard, specifically on the stunning renovation claim. First, what are the legally dispositive facts here?
So the key facts are, sellers advertised the house as a stunning renovation. But the buyers alleged this was false because, well, the renovation was done without permits by an unlicensed company, and it resulted in serious hidden problems, structural, plumbing, HVAC.
And the core legal issue the court had to decide.
The issue is pretty straightforward. Does the phrase stunning renovation count as an actual false representation that a buyer could reasonably rely on? Or is it just, sales talk, commercial puffery?
What rule did the court apply to make that judgment?
They applied the standard rule for puffery. Basically, generalized statements of optimism that are not capable of objective verification are considered non-actionable puffery. The court pointed to other cases where phrases like gorgeous renovation or even best food were dismissed as just opinion.
That feels a bit tough on the buyer, doesn't it? Why did the court say relying on stunning renovation was unreasonable, especially given the high price? What was the court's analysis?
Well, the court reasoned that stunning is a classic example of puffery, precisely because it's subjective. It's an opinion about aesthetics. It's not something you could objectively measure or verify, right? A reasonable buyer, the court implies, wouldn't rely on the seller's opinion of stunning. They'd rely on a home inspection to check the actual objective condition, the structure, the plumbing, whether permits were pulled. So relying on stunning alone wasn't considered reasonable.
Okay, so the conclusion on that specific phrase?
The court concluded the fraud claim could not move forward based only on the stunning renovation statement. That part was dismissed as puffery. Sellers were off the hook for that specific adjective. Tag 3, the rule of the half-truth.
All right, so stunning was out, puffery. But the buyers didn't lose entirely. The court did let the case proceed based on the phrase newly renovated, and especially on the illegal basement kitchen. Now, this is where it gets really interesting because, the house had been recently renovated. That part was literally true. So why was that statement actionable?
Ah, yes. This is the pivot point. It brings us squarely to this really important legal doctrine, the rule of the half-truth. The general idea is, okay, maybe your statement is literally true word for word, but it's still considered fraud if you make that technically true statement in a way that's designed to create a false impression because you left out other critical facts that contradict it. It's actually spelled out in the Restatement of Torts, Section 529. It says if you state the truth as far as it goes, but you know it's misleading because you didn't mention other qualifying facts, well, that's fraudulent misrepresentation. You can't just highlight the good parts newly renovated while hiding the bad parts that totally change the meaning, like renovated illegally and poorly. That's the essence of the half-truth. Tag, be structured dialogue on half-truth, the illegal basement kitchen.
Okay, let's apply this half-truth idea directly to that basement kitchen, probably the most concrete example in the case. First, what are the critical facts about that basement setup?
Right, the facts were, sellers specifically advertised the house as having an English basement set up with full kitchen. And factually, there was a full kitchen down there. However, the sellers absolutely knew and did not disclose that installing that kitchen violated zoning laws. They knew it was illegal and would have to be ripped out by whoever bought the house. And for these buyers, that feature was actually a major reason they wanted the house.
So the core legal issue becomes?
The issue was whether advertising a feature that, yes, physically exists, but is known by the seller to be illegal and unusable as advertised, amounts to fraudulent misrepresentation because they suppress that critical disqualifying fact, its illegality.
What rule did the court use to say the sellers did have a duty to disclose the illegality once they started talking about the kitchen?
The court leaned on a well-established rule, citing cases like Ehrlich and the Restatement Section 529 again. The rule is, when you make a specific statement in a business deal, you're obligated not just to tell the truth in what you say, but also not to suppress or conceal facts you know that would materially change or qualify what you stated. Basically, once they chose to boast about the full kitchen, they took on the duty to tell the whole story about it, including the fact that it was illegal.
And the court's analysis, how do they connect the seller's silence about the zoning violation to fraud?
The court saw it as a clear case of advertising by half-truth. By highlighting the kitchen a positive feature but hiding its illegality, the sellers were painting a false picture of the property's value and usability. It created this false impression that the buyers were getting a valuable functional feature they could actually use legally. The specificity of the claim full kitchen made it more than puffery, and the concealed illegality made that specific true statement fraudulent.
So the final conclusion on the basement kitchen claim.
The court concluded that advertising the English basement set up with full kitchen was an actionable, fraudulent misrepresentation. And similarly, the broader newly renovated claim was also actionable because it misleadingly implied legal, proper renovations while hiding the unlicensed work and defects. #TagVV. Visceral hypotheticals.
Okay, that idea that telling a literal truth can still be fraud if it's misleading. That's really the core takeaway here, isn't it? Let's try to make it stick with maybe a slightly grosser hypothetical. Say you're at a restaurant and you ask the owner about the steak special tonight. The owner smiles wide and says, "Oh, the meat. It was delivered fresh this morning."
Okay, that statement on its face is literally true. A delivery truck probably did arrive that morning with meat.
Exactly. But what if the owner knows the backstory? What if he knows the delivery truck's refrigeration broke down and that fresh meat sat in a hot, unrefrigerated alley for like 4 hours in the sun before it finally got to the restaurant this morning, and then he quickly put it in the fridge?
Well then the statement delivered this morning, becomes a perfect example of a fraudulent half-truth. It creates this impression of freshness, of proper handling, right? But it intentionally conceals the material disqualifying fact, that long period and unsafe temperatures, which totally negates the implied quality. If you ate that steak and got sick because you relied on that misleading statement of freshness, that omission could absolutely be fraud. The rule is pretty clear. If you decide to speak about something specific, you can't use true words to hide a contradictory critical truth. Don't tell half the story if the other half changes everything. ##&V exam framework synthesis.
This has been a really useful deep dive, covering everything from subjective words like stunning to hidden legal flaws like that kitchen. Now, for you, the learner, basing maybe an exam question on this, how do you boil all this down? How do you synthesize the 6 elements, puffery, the half-truth rule, into a practical, step-by-step checklist for spotting fraud claims?
Okay, yeah, having a clear framework is essential. Here's a strict 4-step sequence you should follow whenever you encounter a potential fraud claim in a sales context, like a house sale. Step 1, check the 6 elements. Always start here. Go through each of the 6 required elements. Was there a false representation or misleading omission? Was it material? Did the seller have scienter? Knowledge it was false. Was there intent to deceive? Did the buyer rely? Were there damages? Remember, scienter proving they knew is often the make or break element. If you can't establish they knew, the claim usually fails right there. Step 2, evaluate reliance. Was the buyer's reliance on whatever the seller said reasonable, especially in a commercial deal done at arm's length? This directly leads you into the next step. Step 3, differentiate the statements. You have to categorize what the seller actually said. Is it just puffery? Generalized subjective opinions like stunning, best, fantastic. If yes, reliance is generally unreasonable and it's non-actionable. Stop there for that statement. Or is it a specific representation? Something concrete, measurable, like full kitchen, newly renovated, new roof in 2022. If it's specific, then you move to the final, most critical step. Step 4, apply the half-truth rule. Okay, so you have a specific statement, and maybe it's even literally true, newly renovated. Now you must ask, did the speaker know about some hidden contradictory fact like the renovation being illegal or done shoddily without permits, or the new roof actually leaking that materially undermines or negates the positive impression created by their statement? If they knew that hidden negative fact and didn't disclose it while making the positive statement, then even the literally true statement becomes an actionable, fraudulent misrepresentation by omission. The suppression of the contradictory truth makes a statement fraudulent, no matter the literal accuracy of the words used. #outro until.
So, bottom line here. What's the big takeaway from Jacobson for sellers? It seems pretty clear. Once those sellers decided to speak in their ads, once they chose specific phrases like newly renovated or decided to highlight that full kitchen, they basically took on a legal duty to tell the whole truth about those specific things. That includes the crucial facts about licensing, legality, and the actual quality or condition, not just the appealing parts.
Exactly. You can't use appealing, technically true words to strategically hide known defects or legal problems. You absolutely can be sued for fraud, even if every single word you uttered was literally true, if you use those words precisely to mislead the buyer about some critical condition you kept hidden.
Okay, so here's something for you to think about, a final thought based on all this. What if the sellers in Jacobson had said nothing? What if they'd made 0 statements in their ads about the renovation quality or the basement kitchen, just listed the house as completely silent on those points? Would the buyers still have had a winning fraud claim? Where exactly is that line between a fraudulent omission where you speak a half-truth and just plain non-fraudulent silence? That's something to mull over.